All right, let's continue from what we had seen in the last sessions. We were working on the WIPO's IP policy draft and the issues or the concerns on the artificial intelligence which were being raised in session 1 of September 2019, and the concerns that had to be considered in the second session, which was scheduled to be held on uh, this May 2020. So let's start with, we have already seen the concerns related to the patent law. Now let's work on the copyright and related rights with regard to the artificial intelligence, which were discussed in the WIPO's first session. So the first concern is, of course, should the copyright be attributed to the original literary and artistic works that are autonomously generated by artificial intelligence, or should a human creator be required? So the first concern, of course, which is a concern ever we have started this particular subject. We have discussed that if in case there is a copyrighted work which is being created by any artificial intelligence, even for example the online softwares which are helping helping in change of the spellings and the correction of the spellings, as well as the what do you call helping students for better plagiarism, I would say, rather, that changing the paragraph and with new words and with altogether a new grammar. So should such artificial intelligent created or AI applications created work be given some copyright or some rights of the under the copyright law? So should such copyright be attributed to the original literary and artistic works which are autonomously being done by the the artificial intelligence, and not the human beings, or not with an assistance of a human being, which is done independently by such a AI? Or there should be a requirement of any human being along with such AI for being given or for being granted such rights of under the copyright law. So that is the first ever concern which was raised in the WIPO's different concerns related to AI under the copyright law. The second is, if the copyright can be attributed to AI generated works, whom should the copyright actually vest? Should the consideration be given to accord a legal personality to artificial intelligence? So if at all, if we are giving consideration, or we are considering artificial intelligence equivalent to human beings, or equivalent in a sense that they can also create some work which is protectable under the copyright law regime, then how such attribution of the law, or how such rights should be granted to AI generated work? Should we consider AI or should we accord AI a legal personality, like how the legal how company is a legal person, right? So should the AIs also be granted such legal personality? And then in that case, what will happen? Of course, that the AI generated work would get a protection under the copyright law, but since it would be a protection granted to a legal personality, it can always be transferred from one person to other person, or from one side to the other side. So that can be done, or it could be governed, it could be sold in a manner similar to a corporation, or the companies that that are governed by the corporate law. So we can have such a separate law with this regard, by which we can grant a legal personality to artificial intelligence, and can give them the rights over the work which is being created by such artificial intelligence. Third point is, should a separate sui generis system of protection be envisaged for such work, or should there be a separate sui generis system, a unique system, a system which is, which is altogether different and a new than the existing system. So like maybe like reducing the what do you call term of protection. For example, if AI has created any literary work, the term of protection would be 10 years or 20 years, or maybe with some limitations which are not actually existing in the case of human beings. So should there be such provisions, or a sui generis system for the AI created copyright work was also a concern or a matter of discussion in this particular WIPO's different sessions. Now the fourth one is, should the use of copyrighted work by the artificial intelligence constitute an infringement, and if so, what would be the impact of such rules on the development of the artificial intelligence? So of course we have discussed this in the previous session also. When we are giving or when we are according a right, there would be a counter what do you call duty, right, a duty which should be fulfilled to have some rights. So then in that case, if we are giving such rights to the copyright work, or which we are like to the AI, or if we are granting some rights to the artificial intelligence for the copyright work or under the copyright law, then there should be some duties also. Then of course the one duty would be to look after, or to ensure that there is no infringement of the copyright work by the artificial intelligence. So how that would be developed, or how that can be managed, how to what are the ways to identify that what would be considered as an infringement in case of the artificial intelligence? Because just an example which I gave in the first or second class also, that there are some online softwares where you can paste your article, a paragraph of an article, and it would change the language of that particular paragraph, of course with certain grammatical mistakes, because the AI application for that language change doesn't really work with the grammar. But what if the AI is also equipped with the grammar and all this what do you call language or linguistic equivalence like the human beings? And then if the AI is changing such what do you call work or a paragraph of one particular person which is copyrightable, or which is, of course it is registered, or it is protected under the copyright, and if that is being changed, paraphrased by the by the artificial intelligence or AI run applications, then how to determine whether, or how to identify whether it would be considered as an infringement or not? So that was also a concern, that infringement has to be identified, kinds of infringement, or what would amount to infringement in case of the artificial intelligence was a concern. And of course, with such identification of the infringement, would there be any impact on the development of the AI? Because such infringement should not actually limit the development or the growth of the artificial intelligence, was also something that has to be looked after by these different sessions. One another thing is, should there be limited exceptions to certain acts, or such as use in non-commercial or user-generated works, or use for research? One another question was, should there be some limited exceptions to certain acts of the artificial intelligence? For example, if AI is using a data maybe for the research work, or maybe for the what do you call non-commercial generated work, something which has no commerciality involved, then in that case should it be considered as what do you call protectable or protected under the copyright law? This was a question that was a concern that was raised in this. And the last one is deep fakes. We already know what is deep fake. Deep fake is a technology by which face or the expressions or the person can be changed. An image or a video record or a video within which one individual is presenting or one individual is present can be changed by, or can be what do you call, can be replaced with someone else's face or someone else what do you call, facial expressions. So that is a deepfake technology which is actually booming these days. We will, like, in one or the other form, maybe for the humor, preparation of the humorous contents, or maybe for any other thing, right? Even for what do you call, even in the films and the movies and the cinematographic work also, they do use such technology. Now then, in that case, these are the works which are protected under the copyright law. So in case of the deepfake, the question was, should the copyright system take cognizance of the deepfake? So of course, when you are creating or when you are preparing the IP policy or strengthening the IP policy, you should also look after whether the deepfake should be considered a part of the copyright law, and if so, or since the deepfakes are created on the basis of the data that may be subject to copyright, to whom should the copyright in deepfakes actually belong? For example, if right now, if this particular video of mine, if it has been used or has been changed with the help of the deepfake technology, wherein the face of mine has been replaced by someone else's face from your class, right? Then in that case, that particular 3 or 4 minutes video, or maybe 20 or 30 seconds what do you call, expression or deepfake technology or deepfake video, whom should the copyright over such video remain? That means whether I should be gaining some what do you call, benefits over that particular video, or it should be the only person who's who has been replaced, or who is replacing me. So that was also a question, that on whom should the copyright in such deepfakes belong, and should there be a system of equitable remuneration for persons' likeliness and performances are used in the deepfake. So, or there should be what do you call, equitable remuneration for both the persons, because of course I have also put in my labor and someone else has also put in his labor in creating the deepfake, right, for the same person. So then in that case, both the persons, the original person who's in the video or an image, as well as the person who's deepfaking that particular video or the image, may gain some benefit. Was also concern that was raised, or was considered by these sessions of the WIPO, whereby they wanted to what do you call, strengthen or have or create or prepare the intellectual property policies of the member countries. So this was regarding the copyright regime and the WIPO's sessions and the policy. We shall see the data and design part in the next video. Thank you for listening.